Imagine a parent in declining health signs a new will, or amends a trust, or signs over a new deed at a time that they did not seem like themselves anymore. And after they're gone, the family starts to ask the tough questions. Did they really understand what they were signing? That question is really asking whether they were suffering from mental incompetence, thereby lacking testamentary capacity at the time that they signed the legal instrument. I am Asthana from Southern State Lawyers, and we litigate these types of cases across Alabama. Let me walk you through how this actually works. Capacity is not about whether someone was old, sick, or forgetful. Testamentary capacity is about what the person understood at the exact moment when they signed. In Alabama, the person has testamentary capacity if at that moment they could understand what they owned, who their natural heirs are, the people who you would expect them to provide for, and what the document they were signing actually does. If they understood those things when the pen hit the paper, the document generally stands even if they had failing health. Here's what surprises most families. The legal bar for testamentary capacity in Alabama is low. While considered very helpful evidence, a diagnosis of Alzheimer's or dementia by itself is not enough. Even someone declared incapacitated in a guardianship case can still have moments of clarity that rises to the level of testamentary capacity when they signed a document. The law recognizes that these conditions come and go, and the person can have a clear moment. So, proving that mom had dementia on its own is not enough. You need evidence about her mind on the specific day at the specific time that she signed. So, who has to prove what? Alabama law starts by presuming that everyone is mentally competent. So, normally, the person who is challenging the document has the burden. But there is an important exception. If you can show that the person suffered from an ongoing permanent incapacity before they signed, the burden flips. Now the people defending the document have to prove that the person signed during a clear, lucid moment. And that shift can change the entire case. Because it comes down to that one moment, the evidence is specific. Medical records from around the date of signing, the testimony of the people who were actually in the room, the lawyer or notary who oversaw the signing, and the circumstances, who arranged it, who was in the room. Was this a sudden change that cut out the people closest to them? Those types of details are what win or lose cases. And here is something we see often. Sometimes a case that looks like a case of mental incompetence is really a case of undue influence. A person may have had just the right amount of capacity to sign, but someone close to them used that vulnerability to steer them to sign the documents in their favor. A weak testamentary capacity claim can be a strong undue influence case. Part of our job is recognizing which one you really have. If you believe that a will or trust or a change to an estate plan or a deed was signed without testamentary capacity and are a product of mental incompetence, then timing plays a big role. And the deadlines are different depending on what legal instrument was signed. For a will, Alabama law gives you 180 days from the day that the will was admitted into probate to file a will contest. It's a strict 180 days, not 6 months and not sometime this year. You can also object to the validity of the will while it's pending in the probate court before its admission. For a trust or an amendment to a trust, Alabama law gives you the earlier of these two deadlines. The outside limit is 2 years after the person who created the trust dies. But if the trustee sends you a copy of the trust and a formal notice telling you the trust exists, giving you the trustee's name and address, and telling you how much time you have to act, that notice can start a shorter clock. You then have 6 months from that notice to challenge the trust. Whichever deadline comes first is the one that governs. So, if the notice goes out early, your window may close well before the 2 years are up. For a deed or any lifetime transfers signed while your loved one was alive, The general deadline depends heavily on what legal grounds you're using to challenge the transfer. For instance, if fraud was involved, Alabama's discovery rule may apply, meaning the clock may not start until you actually discovered what happened or should have discovered what happened. These windows are real and they move fast. The sooner you get advice, the more options you have, and the better chance of preserving the evidence you need. There's another side to this. Not every capacity challenge is actually fair. Sometimes a disappointed relative attacks a perfectly valid will simply because they did not get what they had hoped for. If you're defending a loved one's final wishes and they knew what they were doing, that document deserves a strong defense. We provide that too. As Southern estate lawyers, these are cases that we know well. We dig into the medical records and the circumstances of the signing, and we will tell you honestly whether the evidence is there. We work with medical experts when a case calls for it. And because we are trial lawyers and estate attorneys, we can take these cases to court and try them. Whether you're challenging a legal instrument or defending one, we've done both across circuit courts and probate courts in Alabama. If you believe that a loved one signed something that they did not truly understand, or you're defending a document that you know is valid, don't wait. These cases have strict deadlines, and the evidence is a lot easier to gather sooner than later. We have offices in Foley, Mobile, and Birmingham, and we serve families all across Alabama. Call Southern Estate Lawyers for your free consultation. We will tell you honestly where you stand, and we look forward to working for you.